Okay, it is 8:30 p.m. Central Standard Time. Today is Monday, April 15th, 2019, also known as Tax Day. Um, if you haven't filed your taxes by midnight tonight, they're late. Um, I try to always file my taxes early, and it's important. Yeah, if you don't have your taxes in by midnight, then you better file for an extension. Go online, do something, because they're not playing with you. The Internal Revenue, as one person calls it, the Infernal Revenue Service. So that's for sure. But today, usually for us, April 15th is birthday. Celebrated today. My 11-year-old she turned 11 years old today. So that's what we've been doing. So anyway, I welcome everybody to week number 3 already. You know what that means? This is actually the halfway point for you guys already. And we'll have 3 more weeks after this week. And then this course will be over. And to be exact, I believe it's the 7th. We'll see on the calendar in a minute. So it is incumbent upon you to make sure that you keep up with your assignments. Make sure if you have any questions or issues that you reach out to me as quickly as possible, so that you aren't left in the dust, because that's the way it is. So I am going to go over this week's assignments, talk about them, and then I will, if any questions come up, I will address those as well. So let's share my screen right now. All right, so I'm not going to share this information because it's already gone over with. All of this is I've gone over with you. So I come all the way down to the rubrics. Many of you have done okay with the rubrics. Week 1, which is what I've graded so far, by the end of this week, I will have graded week 2. Some of you didn't get my message with this preamble, where I indicated that it should be at least a page, even if it didn't say, because in order to properly do this, and then you also need to provide citations in the body and references at the end. So, with your spelling, and then please, some of you have submitted your assignment single space, should be double space, and should be in paragraph form. I had one student to submit an assignment. It was one long paragraph, the whole assignment. You need to have your topics, because you start out with a topic sentence, and then you go in and you provide the details and the information, and then you conclude, and then you set up another paragraph to deal with the next topic. And I'm not going to do a grammar class here, but I will say that the average is 5 to 6 sentences. You can go more than that, but when I see a paper that's lengthy in terms of it, then you're going to lose points for that as well. So anyway, in this assignment, you need to make sure that you added the information to rewrite the preamble. That was the biggest portion. And, one paragraph, 2 lines is not going to cut it. Remember, you're in college, and you're expected to do some research, maybe think about things, and then provide citations to support it. And the rewrite speaks to all possible future issues that you might think of in terms of that. So that's for week 1. Okay, and then week 2, you guys I haven't done the briefing of the case, but I did provide you with some guidelines, a whole lot of information to help you to make sure that you set up your proper format. Always remember that all your written assignments should have a cover sheet, and they should also have citations and in the body and references at the end. So you want to make sure that you satisfied this, and I showed you how to set it up with the written assignment, with the information I emailed to you. So that brings me to Module 3. Today, freedom of the press and the right to a fair trial. And you're going to, of course, do some research. Remember, you're not just using your textbook. Don't lean heavily on that textbook. So what you're going to do is you're going to describe if they believe the press, if your press has an effect on jury pools and fair trials, you're going to write about that and maybe comment about the effects on that, and then explain the First Amendment position of the freedom of the press, and then the right to a fair trial as defendants are entitled to. So there's a balance between them, and you discover that from your research, and so you make sure you have your citations and your references. So we're going to come back to that in a minute, but that's the source that you're going to be looking at there in terms of rubric. So we scroll down here, and you see for this week your Fourth Amendment project, relevant case law, includes case briefs with proper citation related to their chosen area, write a synopsis on at least 3 secondary sources, and then make sure it satisfies the pagination requirement, which I'll go over with you in a minute. And so you got 2 written assignments this week. And then, of course, you get down here and you see, again, remind you about your lectures. You see 1 and 2 already down here under recordings. And then I emailed them to you as well, as I will do tonight for week 3. And then it tells you that we have 3 more lectures after tonight, and we'll discuss those accordingly. And you know that you must either attend the lecture and provide me with the keyword, or you look at the archive and then provide me with the keyword or phrase. And I always tell you what it is at some point. Sometimes I tell you throughout it, but you can almost be rest assured that by the time that we finish the lecture, that I will have given it to you. Okay, so let's go to the top here so we can get to the other side. Here we go. I'm not going to go over this stuff already. We did the academic integrity thing week 1. We did talk about the writing process and APA. If you're still struggling with that, that's still right there to help you. The welcome announcement remains as well. So now let's take a look and see what's in store for week 3. So we're going to talk about protecting basic freedoms. You got chapters 5 and 6 of constitutional law, and I sent you the PowerPoints and the information that can help you. That is the IM information, which is basically an outline of the topic for the quarter. For that week, matching with the chapter that coincides with the textbook and matches with the PowerPoints. And so then dealing with the activity, First Amendment, and then gun control, which is, anyway, we'll get into that in a minute, very briefly. So anyway, then this tells you about the lectures and where you can find it. And if you're here, you already know it because you found it. And then the discussion assignment. As you recall, previously you've had 2 discussion assignments. This week you will have only 1. Do you know why you're having only 1? I'll answer it for you. Because you also have a midterm exam that'll be due this week as well, which we'll be talking about in the next paragraph. So your discussion assignment involves gun control. Of course, you know the deadlines are the same. Initial post Tuesday night, tomorrow night, 11:59 p.m. Central Standard Time, and reply post by Saturday, 11:59 p.m. Central Standard Time. You already have learned that If you put a one-liner or a short answer in there, you're going to not get points. You also have probably learned already that if you submit your posts on Sunday, both of them, then you're going to get 0 points because the forum is over. You also learn that if you are late with your post, you're going to lose 1 point for each day up till when the forum ends. And now, I could do more than that because it says usually 10%, but my policy has been 1 point, which is very generous in light of the fact that you get 55 points for the entire. And the way I break it down is I give 28 points for the initial post when all else being equal, and then I give 27 points for the reply post. So if you add those two together, that is 55 points. And regarding, again, the discussion assignments, I want content. I don't want short answers. And I do encourage more than one reply post. And several of you have taken me up on that. And you don't get additional points, but I do let you know I appreciate it as well. So that's it on the discussion post. But once again, there are a few people who still didn't get it. I had a person today to submit to me week 1 discussion post today, and I had already said they didn't submit any posts when I sent when I put it in the grade book for week 1. But after that, it is still not going to change it. I cannot extend discussion posts beyond the period in which the discussion forum takes place. You saw that when we went over in the syllabus. Though I have the power and authority with written assignments to do that, I cannot do that with discussion posts. Finally, the written assignment for this week is freedom of press and the right to a fair trial, which we just discussed. I went over with a few minutes ago, and then your Fourth Amendment project relevant case law, and then your midterm exam, which is timed. Now, I do recommend that you defer your midterm exam to be the last thing that you do for the week, because it's going to cover in weeks 1 and weeks 2, and then, of course, weeks 3. And then, you know, get some time after you do that. If you could complete the mid-quarter student survey, I'd appreciate that, so that, you know, you can have a chance to express what you like, what you don't like, you know, what you think could be improved in terms of it. Most of the time, students will put in their comment, it would be better if I got my grades faster. I say, well, the college is set up because they recognize that we full-timers have over 100 some odd students. Some of you are in, well, most of you guys here are in bachelor completer, but you know, if in other classes that you've been in mine, you've been in more than one of my classes. And so I explained the way that the grading operates is that, so week 2's assignments, which were just completed yesterday, they were due yesterday by 11:59 p.m. Central Standard Time. So now I'm grading them this week. I've already gone through the discussion posts for week 2, and because it's past the period. And then I also, and then where you haven't submitted an assignment, you'll see a 0 in there, indicating that you didn't get it in on time. Now that doesn't mean that you can't still submit it because you see the 0. That means that you, it's letting you know, and it's letting the advisors know that you didn't submit anything that was there. Few of you got hit with Grammarly plagiarism hits, but not a lot of you. So I'm glad to see that that's being dealt with there in terms of your writing. So anyway, your midterm exam is very important, and you want to make sure that you follow up on that. And then you know what my motto, Adversity is Springboard to Success, is all about. You were given that information the very first week. So now let's go over to the course calendar so you can see another place where you see the schedule, so that you understand where we are. And you see this area right here. This is where we are today. Today is the 15th. Tells you about the lecture. You click on it, it opens up. Your initial post tomorrow, your reply post Saturday, your written assignment, your course project, your midterm exam. Those are the 3 assignments. And then mid-quarter survey is voluntarily and not graded, and it is also anonymous. And so that's what you're going to have. And then scrolling down again, you'll see just what I said, that the course actually ends on the 7th of May. Okay, so here we are right here. So we've got 3 Mondays left, so which is 3 weeks. But the course ends on this day at midnight, 11:59 p.m. And I actually, if you click on it, you'll see it says it right here. See? So don't think that, well, okay, that means for this week here, for the last week assignments to start, that I have all the way until the 12th, but you do not. It ends on the 7th. And you know that by now because many of you had 5.5 classes before. Okay? So let me close that down. And let's jump into the module itself. Let's revisit the assignments. As you can see, your relevant case law, and we started talking about this is a course project, and it explains what you're supposed to do regarding the 4th Amendment. And just be sure that, see, let me say this. You have to submit the case briefs, which you already know how to do. And, you know, for use for your final project, write a synopsis about a paragraph long on at least 3 of your secondary sources. And then your paper should be proofread by you for spelling, grammar, and punctuation. Okay? So you should do that. Now, I would just hazard to say that you can't do this in a half a page. You probably can do it in a page, maybe even a page and a half to 2. But you got to make sure that you provide the correct information, and you'll be graded according to that rubric that I just gave. And then you know when it's due. It's due, just in case you don't remember, click over on this, and you'll see it at the left. Sunday, the 21st, which is this Sunday coming up. And you get a possible 100 points if you satisfy all the requirements. So it's very important. Then your written assignment, freedom of the press and the right to a fair trial. It says it's a 1 to 2 page paper, not 1 paragraph, not 2 paragraphs, but it should be a page. It's okay to even go to 3 pages, but then you have to deal with these issues here, and you're going to provide citations and references accordingly, okay? And again, click on that, and it tells you when it is also due, and you get 80 possible points for that. So it is important that you check your rubric and make sure that when you submit your assignments that the rubric is complied with. That's the key. Then I already talked about the discussion forum. And then the quiz is what we call, that's your midterm. But that is the quiz. And it tells you 15 multiple choice and true, false type questions, timed, and it's set for 15 minutes. So what does that mean per answer? 1. So you'll have only 1 opportunity to complete this exam. There are no retakes. By starting the exam, you agree to abide by the academic misconduct policy, which You are well aware of it from that video that we went over week 1, as well as what's in the syllabus as well. Okay. So the key thing is we're operating on honesty and integrity. All right. So if you have any problems, contact personal support for help with exams. That's funny. They're not going to give you any answers. That is if you have technical problems that exist and take place, because you want to make sure, just like when you start any other exam, the clock's going to run. And don't say that I was interrupted by my kids, or I was interrupted by the doorbell or something. You know, it has to be a 911 situation that interrupts you. Let's say, for example, and I'm not giving you an idea to use it. Let's say, example, you start your exam, and then a fire breaks out, and then you have to leave, and then come back, or a fire alarm goes off, and you have to vacate. Then we will consider that. So I say that to you. It has to be extenuating. Okay, that's the bottom line. And then, of course, your live classroom, you already know how that works, and then your surveys. And that's the assignments. Any questions? If so, type them in the chat box, and I'll address them. If not, I'll presume that you're up to speed as far as the written assignments for week 3. I'll wait a second. If you think of something even along the way, feel free to type it in the chat box, and then I will see it pop up, and then when we get back into the classroom, I'll address them then. Okay, looks like there aren't any. Okay, so let's go to the lesson itself. So we're dealing with the freedoms of the First Amendment, the freedom of speech, and how it impacts the criminal justice system, and then dealing with a little bit about our the Second Amendment and the effect on the criminal justice system, and then a little bit, not a lot, about the gun control debate. When I did the 11-week course, there was one module that was all about that, and I went to it extensively. I'm not going to do that in this course, but I am going to share with you some issues. First Amendment and gun control is that topic there, and then you see the written assignments here. Okay. So first of all, let's talk about before we even get into the issue about gun control, which is the second issue. But it says in the First Amendment that Congress shall make no law respecting or an establishment of religion, or prohibiting the free exercise or abridging the freedom of speech or of the press, or the right to the people to peacefully assemble and to petition the government for redress of grievances. Summing it up, I mean, the whole thing can go. I mean, we could do a whole lecture on each of those clauses. The establishment of religion, the free exercise of speech, abridging the freedom of speech, and then dealing with the freedom of press, and the right of people to protest and petition the government. So we're going to do it in short fashion. First of all, number one, understand this, that the First Amendment was written with the mindset that the people of the United States should have protection to be able to exercise free speech. There is no absolute protection. For example, you cannot say yell. We always say there's a case that you cannot yell fire in a crowded theater, because if you do that, then somebody says, well, I have a right to say that. No, because you're endangering lives, And what will happen is in a crowded theater is the stampede can take place and some people can get hurt. And so you're inciting that situation. Therefore, you could probably be charged with disturbing the peace or something further, depending on the extent of injuries and or damages that take place to people. Maybe some people be killed, and you might be charged with some form of manslaughter or something, depending upon the jurisdiction. The point of the matter is that you don't have the absolute right. It is based upon a balance between what the Constitution says and maintaining order. I didn't say law and order. When I say maintaining order, I mean so that we have an orderly society. An attempt to provide respect for people's ability to be able to have different views. And so the First Amendment is a real strong constitutional issue, but as it says at first read, it doesn't appear to have much to do with criminal justice, but it has more to do with the freedoms than crime. But if you look at it further, you discover that it deals with things like obscenity, or and what I just told you a few minutes ago, protecting free speech. And also, for example, if you want to burn a flag, you can burn the flag. People might not like it, but the First Amendment allows it as long as you're not burning somebody else's flag or somebody else's property. Then you got criminal damage to property and those kind of things. So if you notice, the American flag is used all kind of ways, and then people can express themselves verbally. Now, here's the thing: when they express themselves verbally, if it's established that the statement that the person expresses verbally is to incite or either to harass someone, then it's not going to be protected by the First Amendment. For example, burning a cross is a symbol that someone might utilize to try to demonstrate that they don't like that person, they're racist or whatever it is. So the KKK usually will use that. It's already been established that this is something that is not tolerated and that it's not free speech. On the other hand, a person raising their hand to express black power or white power or whatever kind of power, they can wear T-shirts, sweatshirts, and all those things. That's fine. That's a different thing. There's a case called, I'm drawing a blank on it, I think it's called Tinker. It's Tinker. But anyway, the armband case, which allow protests for individuals to wear armbands and things like that. And you notice that when officers die, what they do is they put a little thing over their badges to demonstrate, the loss of a comrade. Those kinds of things are acceptable and okay. There is even allowed marches that people may not be happy to see. For example, in the Jewish community called Skokie, Illinois here, the Nazis and the Ku Klux Klan have been allowed to get permits to march. And the reason for the permits to march is for them to be able to exercise their constitutional rights to march, but they must do so following the requirements that are set out for their permit. And the main thing is they're not to curb the speech, but more to provide protection for the individuals, balance it with the fight that there's going to be some pretty upset people at the demonstration. And so the key thing is that you need to look for is, are you inciting somebody by your action? Not that they don't like it, not that they disagree with you, but are you, up in somebody's face and those kind of things. You can even say, for example, you express your position about the police in a contrary fashion, as long as you don't say it to the face of one of them. You can express your opinion verbally. There are some police officers who have taken offense to that, and like the old term that's used when I was coming up, and it's still used now, is pigs. Off the pigs or something like that. Now we're in a society where words do create issues for people. Back in the days, in the 60s, you could say that and it'd been different. Also, what you cannot do is even a simple comment like, I'm going to kill the president, or I'm going to kill Senator so-and-so, or this person. Can't do that. You will go to jail. The feds will be at your house. People have posted crazy things in Facebook, on more Facebook than any other place, maybe sometimes on Instagram, but Facebook is usually the source. And then people have been arrested for those kinds of things because the way that the law is. And that's because of the society that we live in right now. So you should be aware that the application of the First Amendment is going to be determined pretty much by how society operates. So dealing with obscene material, in the second paragraph here, there's a famous case, Miller versus California, that says that obscene material is not protected by the First Amendment. And the court then set a test out to determine whether speech is considered obscene. Now, here's the test. If the material, the average person applying contemporary community standards, see, remember I told you it deals with the signs of the time, would find that work taken as a whole appeals to prurient interest. Now, okay, Professor Wright, what's prurient interest? One Supreme Court justice, a long time ago, Justice Douglas, said, obscenity, I don't know what it is, but he said, I know it when I see it. And so the point of the matter is that what it amounts to with prurient interest is that it has to be like gross, out there, that kind of thing. So, but if the average person, now remember, the average person, so who's the average person? The average reasonable person. It is a standard that's determined based upon the times, and the times do change, and it does change that. So I think what I am trying to say is that if you're a prude, that doesn't necessarily mean that obscenity will apply, okay? But then it says also, here's the other part, whether the work depicts or describes in a patently offensive way. Remember, these are relative terms, but court cases have decided what those mean, and that's how it's going to turn out. Sexual conduct specifically defined by the state law. So if there's some state law that says certain things that you cannot do and should not do, and the work depicts in a patently offensive way some sexual conduct, then you're probably not going to be protected under the First Amendment based upon the Miller case. And then the third part is whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So if there's some scientific value in nudity or some political, like for example, I think it's Atlas, I think, that you see is not dressed. If you see some pictures of Adam and Eve, they may not be dressed, and then they might have, the female breasts showing, or things like that. Just that alone does not make it obscene in terms of it, because it might have some artistic value, some political value, and a lot of satire fits under that particular thing. So if a state obscenity law is thus defined. The First Amendment values are adequately protected by ultimate independent appellate review. So it's determined on a case-by-case basis, and that's pretty much the way it is. And that kind of says it. So there's no paintbrush that's used broad, but you kind of begin to know when something is considered as obscene. Okay. And that's all I can really tell you. We could go on and ad infinitum forever. So I guess the long and short of it is that the First Amendment does not protect what is determined as obscene. Who determines whether it's obscene? Well, the legislature writes laws, but who interprets those laws? The courts. So it can go all the way up to the United States Supreme Court, and so that's what happened here with Miller versus California, finally ultimately being presented in 1973, and it's still good law even today. So people who violate that could find themselves in the criminal justice system. That's the point that we made earlier, that the First Amendment does have something to do with criminal justice and so forth. All right. So what does this have to do with criminal justice? Again, looking at pornography, and look what it says. Pornography is a form of personal expression. So we'll look at the First Amendment for guidance. Under the obscenity test above, the Miller test as we call it, pornography might, did you hear the word, might be protected if it is not found to be obscene. I hear, huh? You know, yeah, I know. See, I went to law school. I studied political science and dealt with this stuff from that perspective, and then practiced as a lawyer. I can just tell you that there's no one way. And like I said, I'll go back to what I said earlier. It changes with the times. People are doing stuff now that they didn't do when I was a kid, legally. They're doing stuff that they're not allowed to do things that took place. Like, for example, I remember coming up on television and watching TV shows, and some of you might not even know what I'm talking about. Ozzie and Harriet, Father Knows Best, and those shows. I Love Lucy. Well, in those shows, particularly in Father Knows Best, let's see, I think even the Dennis the Menace, some of the other shows, the husband and wife oftentimes had twin beds. Yeah, that's what they had, you know, on the TV shows. Now, you know, my wife told me once, we get twin beds. I'm saying, we're not doing that. But anyway, you understand what I'm saying. So what's done in somebody's bedroom is their private thing. My point being is that when it came to putting it out in the public for people to see, they operate. And then also the pajamas that were worn, you know, were pajamas. I mean, like real pajamas, not nighties and stuff like that. And, you know, even the bikini issue, you know, came about. But you know what I'm talking about. So it all changed with the times. So getting to the point here, it says pornography might be protected if it's not found to be obscene. But like I said, that varies with the times. But child pornography, now that's a whole nother issue. So they show commercials on TV with a child crawling, and you know, they're butt naked, but they're just crawling, and they're trying to make a point about something, or a diaper rash or something. That's not obscenity or pornography or child pornography. I have pictures of my kids in the tub when they were little, and you know, I have those pictures. I don't post them on Facebook because they will get mad at me. But the point of the matter is that that's not child pornography. Child pornography is when a person uses pictures and used to excite them on a sexual level, or children involved in sexual acts that are used in videos and pictures. That's when we get into the issue of child pornography, which is outside the protection of the First Amendment. Okay, so that's when we get into the New York versus Ferber case, where we'll come down to that. I jumped ahead, but we're going to come to that in just a minute. But it gets to that. So is this protected under the First Amendment or obscenity laws due to the fact that children are a special class? The court has determined that they deserve even more protection than what the obscenity laws protect. So if it's an adult, that's different. But if it's a child, the child is a minor, and so forth and so on, looking at that. So then we come to the Ferber case, where the court held that the states can have more rigorous regulation to protect children than not just the Miller test. So that is how we deal with child pornography in terms of a case that came out in 1982, 458 U.S. 747. Whenever you see that for the number, I said this before, and then you see U.S., that means that it's a Supreme Court case. It says it's found in volume 458 of what we call the United States Reporter, United States Supreme Court Reporter, kind of, sort of that way. And if you ever do research, you'll know what I'm talking about. And 747 is the page that the case starts, and the year that it was decided and handed down by the Supreme Court was 1982. So the court went on to say, and using this quote, and it makes a whole lot of sense, when a definable class of material such as that covered by New York statute bears and is so heavily pervasive on the welfare of children engaged in its production, the balance of competing interests is clearly struck, and it is permissible to consider taking these materials as without the First Amendment protection. So we're protecting children and sacrificing First Amendment protections because the harm and damage to children, that's the essence of that particular point. So before I go to guns, and there's no material here, but I do want to say this to you, that the freedom of the press is paramount. But when it comes to an individual trial, more and more cases now have reached the stage where cameras are allowed in the courtroom. One of the biggest cases, or the longest running cases that everybody became familiar with, was the O.J. Simpson case. And now it's kind of taking place across the country where courts are allowing cameras so that the public can see. But then before that, the press is always able to report on what's happening in the cases. And the key thing that when it comes to juries you should be aware of is that is why juries are sequestered and kept away from the news publications, because the public has a right to know, but that the jurors shouldn't be subjected to that because it might taint their decision of being fair and impartial. And so that's the point there. So there's a balance between that. But you also should be aware, and you've probably seen this, where newspapers, TV stations, and so forth, news organizations like Associated Press are able to file Freedom of Information Acts, or FOIA, motions or requests, and are able to get things that they want to report on. And so a lot of times, for example, dealing with a case that took place here, the Jesse Smollett case, I have in my possession the full police report that it was retrieved by one of the news outlets and posted on Facebook, posted on the internet, on Google, and anyway, it was on Google, and I was able to Google it and download a PDF for the entire thing. However, though, what they did do was they redacted information like the address or some particular witnesses' names that they wanted to protect and those kind of things. So the key thing is that the newspaper people are able to get that information as well. Now, there are instances where individuals, not the news media, but individuals are subjected to instances where the judge says to them, you can't comment to the press or even the lawyers or anybody about what's going on. They issue what we call a gag order, and if you violate that, you could be found in contempt of court. So some have argued that that creates a problem with the capacity or ability of the press to be able to report, but it's not really true. It's not really true. So what is it? We balance the right of the defendant to a fair trial, try to protect it as much as possible. That's what the judge's job is to be able to do. And so here's what some people have said to me, and I hear them on this. They say, okay, you can sequester the jury, you can keep them, regulate what they see and read and who they contact and all that stuff. But what about if it's a bench trial? Well, that's a whole nother animal. You can't sequester the judge. You can't put the judge and lock the judge up until the case is over, because the judge is going to be free to go home or wherever else they go. So what we depend on with bench trials in those instances is that the judges will not be influenced by what they may read in the press and those kind of things. But because judges are human, there are things that are affected. Like, for example, even jurors. So, for example, I know oftentimes as a defense attorney, I'll make an objection to something that takes place in the court, or a statement or something, and the judge will sustain it, which means that he'll say it can't be used. And he'll turn to the jury and tell the jury, disregard that information or statement. What do you mean? Are we going to pause, take breaks, and do lobotomies? Because that's the only real way that they're really going to be able to disregard it. But it is the way it is. So you begin to understand that the press has to be responsible in terms of how they do things, and there are certain principles and that guide the press in terms of being responsible to the community, and not just, I'm the press, I need to tell the people everything. Well, you can't tell them everything, but you can try to remember you're responsible as press members to be able to provide the news, but not to damage the right of the defendant to a fair trial. So that's kind of like that, okay? So that's what I did want to say that, because they didn't put anything in here about that. And so as you're doing your research, you're going to find some pretty interesting things there. So let's conclude. We've got about 17 more minutes to go. And let's talk about a topic that is, like, I call it a ball of fire topic, the Second Amendment. The Second Amendment. People, there's no in the middle of that. There's either you're pro the Second Amendment guns, or you're for gun control against it. All right? So here's the deal, the way it works. The Constitution actually says this. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to bear and keep arms shall not be infringed. Now, when this was written, and this is what I know from my research in history, and a lot of people don't like to hear it, but it is what it is, and judges use it and manipulate it around. when this was originally written in the context of going back, I was trained in law school at Northwestern to always go back and study the history of how a law came about and how it was derived. Well, it starts out by talking about a well-regulated militia. Now, that's like the Army of today, and protection of armed forces, protection of the state, the National Guard, the Coast Guard, and those kind of organizations. So it says, the rights of the people to keep and bear arms shall not be infringed. Now, in the context of reading that all together, the intention was, first of all, number one, handguns were not anticipated and did not exist at that time. I mean, they had little muskets, but that wasn't the deal. And there was no automatic or semi-automatic weapons, okay? And so what they pretty much had in mind was allowing the military to possess the weapons to protect, and also came over to law enforcement agencies and so forth. It dealt with rifles, pretty much, and that's the context that it was in. Now, I already know, man, I said, no, yes. But there are court cases that disagree with what I'm saying, but that is when you go historically back and apply the literal interpretation and the context of where it was written at the time. So now, what people like to do is they don't want to read the first part. They read the right of the people to keep and bear arms shall not be infringed. So now what they're saying is that we have a right to have guns. Well, to be honest with you, yes. However, there should be and need to be gun control. And gun control should be to the extent that you protect the public from people who are criminals, who can legally get guns. I'm not talking about illegally, who can legally get guns. Let me tell you, when I was a police officer and working in a town in the south suburb of Chicago, and I was working too a little bit with the Cook County, they had a task force. And so what we did, there was one known gun shop, it was called Chuck's Gun Shop in Dalton, and it was known that individuals who were gangbangers would be able to go in, who never had records, could do what they call straw purchases. They would purchase the weapons, and they were getting numbers of weapons. They weren't just walking out with one or two guns. And they were giving them over the counter with little or no waiting period. And then the Brady Law came about, where, came about because when President Reagan was nearly assassinated, and one of his cabinet members was wounded and at that point disabled permanently, they came with the Brady Law, which dealt with periods and background checks and delays in giving guns to individuals. Well, it's been demonstrated time and time again that these waiting periods are objected to by the ever-powerful NRA, National Rifle Association. And as a result, whenever legislation comes up regarding gun control, they lobby strongly. And unfortunately, too many of the legislators are, as we say, in there, they got them under control. And they put a squeeze on them. So what do if you vote against it? They lobby and they campaign against you, and then you're out, and they put somebody in there that will do it. Even though guns are killing people at tremendous numbers, it still is allowing it to take place. So the debate goes on and on, even so much that there was legislation that former President Obama put on that required some very strenuous background checks for individuals to try to minimize guns getting into the hands of individuals who have mental problems. And our current president drew back on them because anything that has that former president's footprints or fingerprints or his name on it, you know how he feels about it. And so he will try to change those. But the point of the matter is that anybody who doesn't see the seriousness of what guns do, and then I hear people say, it's not guns that kill people, it's people. It's people using guns that are acquired. And now we're dealing with all these shootings, dealing with the high school shootings, the shooting of former Arizona Representative Gabrielle Giffords, and you know, her husband, I think, was running for office, and he was an astronaut. And then most recently the Trayvon Martin. Well, let's talk about some other more recent ones. Let's talk about what happened in Vegas. Let's talk about what happened down at the school Parkland down in Florida. Let's talk about what happened at the nightclub in Orlando. You know, and let's talk about most recently here in our community here in Chicago, Illinois, at a workplace, Henry Pratt, where a guy was being terminated, and this guy had a gun, and he pulled out his gun and shot and killed 5 people because he was being terminated. And then it was discovered that his FOID card, which is firearms identification card, had been revoked sometime before that, but that he fell through the cracks because everybody's trying to say it's not my job to go and get the weapons. Well, the key thing is this, people, is that again has to do with the Second Amendment right and the right to bear arms. So, so the issue of gun control is, as it says here, constantly in our minds. And you know what, I was telling somebody that when someone you know close to you or a family member gets affected by guns, semi-automatics, which is crazy. You can go to a gun show and buy a semi-automatic weapon. They've done some things with bump stocks and stuff like that, where guns are modified to rapid fire. Why you got those? Those are to kill masses. I call them weapons of mass destruction, in my opinion. They're not hunting. They're not for hunting. They're for hunting people. And so the question is, how important is the right to bear arms when the right puts guns in the hands of the wrong people? And that's what I'm talking about here. So it's important to examine both sides of the debate. It says here, those that support the right to bear arms want the ability to protect themselves. Let me tell you something. I am 68 years old. I only had a gun 4 years. And the reason I had that gun was because I was a law enforcement officer. That's the only reason I had the gun. After I left that, I turned it in, sold it for loss of money because I didn't want it. I didn't want a FOID card or any of those kind of things because I had done pretty well, even in tough areas. Unfortunately, there are innocent individuals killed. Kids get a hold of the guns. Also, there are people who have killed people coming in their house late at night, maybe a family member, and they hear a noise and they go with a gun and bam, and they shot somebody that's a loved one of your own children or a spouse or something. So the whole issue that is, it says that those that support the right to bear arms want the ability to protect themselves and to exercise that right that I was talking about as is written in the Second Amendment. So and let's go on. There's no yes answer, or right answer, or wrong answer. Every state has different gun laws. For example, we have, as I was talking about here in Illinois, the FOID card, if you want to own a gun. And then there's now we had for a long time fought carry conceal. Illinois was one of the last states to allow it. So now there's carry concealed, where people go under and get background checks. And like that guy that killed those people at Henry Pratt had undergone that, but there was some information that wasn't made known at the time he even got the card. And so it's problematic. And so you got states like Florida that don't require a FOID card or any type of permit except where the person has a concealed weapon, So each state has different open carry, where people are carrying guns. You go down in Texas, you think you've landed in the Wild West, but you have, and people are able to have guns on top of their trucks and openly and all that. It's something. So we're in a society where we deal with that. So anyway, that brings me to the end of this lecture. And like I said again, the debate on federal and state regulation of guns will continue forever, and will be adjusted and changed over long periods of time, and it'll be based upon circumstances that people find themselves in. So anyway, so what do I want to say to you to get your points? The thing that I want to talk to you about is what we talked about at the end: gun control. That's it. Give me that, and then you'll get your points. You get your 10 points. Do it timely. Remember, if you give that phrase after Sunday, you're going to lose a point for each day that you do it. So you don't want to do that. So, and that's about it for the day. I hope that you learned a lot. I hope that I've helped you, because that's my goal, to clarify some things, get your juices flowing. So I hope to see you guys next week at the same time, 8:30 p.m. Central Standard Time, for week 4 of constitutional law. So I'm going to say good night to each of you, and thank you for attending tonight's lecture. Bye.